Hey there, Consumer Warriors. John Skiba here from the Consumer Warrior YouTube channel. And on today's video, we're going to talk about Chapter 7 bankruptcy. I'm going to give you kind of a general overview of the entire process. But if this is your first time here to my YouTube channel, please go ahead and click subscribe. We've had a lot of subscribers. If you haven't subscribed, if you've been watching for years, please do so now. Please go ahead and subscribe. And let's go ahead and jump into the video. Okay, Chapter 7 bankruptcy, in theory, is actually a fairly straightforward process. As far as like a federal proceeding, it's relatively short. Most Chapter 7 bankruptcy cases take about 4 to 5 months from the day the case is filed until the court enters the discharge order in your case. Now, the discharge order is that final order from your bankruptcy judge that says,
"You're free. You've got a fresh start.
You're done. These debts are eliminated. They're legally wiped out, and there's nothing your creditors can do to continue to collect." But before we go back to the discharge, let's rewind this a little bit. Let's start at the very beginning and talk about the various stages that you're going to go through as you file Chapter 7 bankruptcy. So the very beginning is really an important part, is really where we're gathering information. Like I said, I'm an attorney here in the state of Arizona. I help people who file bankruptcy, and part of the biggest part of the job in helping people to file Chapter 7 is getting all the information and documents necessary to complete a typical Chapter 7 bankruptcy case. Now, a normal Chapter 7 filing is literally about 100 pages long. So there's information on creditors, on your assets, financial transactions, income, expenses, your budget, all those kind of things have to go into your bankruptcy documents. And so it becomes necessary for us to work with you to get all that information. Sometimes I've had clients say to me that they're really frustrated because they feel like they're doing all the work because we request all this information. And I get that. It is a lot. It's a lot of information they need. But as an attorney, we really have to have our clients cooperate with us to gather all the information because we don't have access to bank statements and all those types of things. One thing that we can help with is I subscribe to a service set up for bankruptcy lawyers to download information from your credit report, so I can generally get account numbers, balances, the creditor's address, all those kind of things from the credit report so that you don't have to. So like in my office, we will download all that information, provide you with a copy of it so we can make sure we're not missing anybody. If there's any creditors, like often medical bills, those types of things actually don't show up on the credit report. So the very first part before the case is even filed is super important because there's a lot of information. I can tell you in my office too, where we start with document collection, we request 6 months of bank statements from every account, 6 months of pay stubs or pay records of all sources of income that are coming to your home, and the last 2 years of tax returns, both federal and state, need to be provided to my office so that we can help you to get everything drafted so it can be ready to go to the court. Once it is ready to be filed, the case gets filed with the court, and immediately the court enters an order called the automatic stay, and it's literally immediate. We file these cases electronically, and immediately an order is kicked back that states that your creditors can no longer do any type of collections against you. I'm talking no phone calls, emails. They can't sue you. They can't garnish you. They can't foreclose on you. They can't do any of those things because this court order stops all collections. It generally takes the court about 24 to 48 hours to get everybody notice. They do mail out a physical hard copy to your creditors, but also a lot of the big banks actually receive electronic notice from the court when a bankruptcy is filed, and that will stop the collections in their tracks. If you file bankruptcy and you have a creditor who's still calling you, one, you can give them your bankruptcy case number, and that should stop it. You should also notify your attorney that this creditor is still calling me and bugging me so they can reach out. Maybe there's a bad address, something along those lines. So once the case is filed, the automatic stay is entered. Then if there's any remaining documents that need to be filed, there's usually like a 2 to 3 week window when those are filed. And then we get ready for the one time when you actually have to make an appearance in a hearing. This is called the Meeting of Creditors. Sometimes it's referred to as the 341 meeting. This is the time when you meet with the bankruptcy trustee. Now, who is the bankruptcy trustee? This person works, technically they're a subcontractor to the Department of Justice, but they are called the Chapter 7 standing trustee. Their job is to make sure that you submitted everything that you need to submit as far as documentation-wise. They will also review some of your bank statements. They may review your tax returns. And they hold this particular meeting. Now, the meeting of creditors is a little bit of a misnomer because rarely do creditors actually appear. Your creditors are welcome to appear. I can tell you in over 20 years of doing this, maybe a dozen times have creditors appeared at one of these for one of my clients, and I do these almost every day of the week. But usually what it is a meeting with the bankruptcy trustee, you, and your attorney. What they do at this meeting, they put you under oath. They're going to ask you if you reviewed your bankruptcy documents before they are filed, if the information contained within there is correct to the best of your knowledge, if you listed all your creditors, if you listed all your assets. They're going to ask you, if you live in Arizona like I do, if you have lived in the state of Arizona for at least 2 years before the filing of your case, and if you have filed any prior bankruptcies in the last 8 years before filing this case. And then if the bankruptcy trustee has anything specific about your case, they will bring it up at that point. Now, the trustee's job, in addition to looking at the documents, in addition to having this meeting, they're going to look and see if there are any non-exempt assets. These are assets that are not encumbered by loans or liens and also are not protected under one of the exemptions in your state. They're going to see if there's assets that can be sold with the benefits and the proceeds, and then going to your creditors. These meetings are nationwide now. They're done via Zoom. Now, in the old days, pre-COVID days, we used to actually have to go down to the courthouse, or there were different places throughout the state of Arizona where these meetings were held. So they were done in person. Since COVID, they went virtual. It was done via a Zoom conference. They permanently changed that nationwide now. The 341 meeting of creditors will be done via Zoom. Sometimes that's the hardest part. We have to work a lot with clients who are not used to using Zoom, but you can use a phone, a laptop, iPad, whatever you have to be able to do that. So once the meeting of creditors is done, about 60 days after that meeting, in most cases, the court will enter the discharge order. Before they do that, you are going to have to complete a second financial management course. I don't think I talked about that, but before you file the case, you have to take an online credit counseling class. It's like a 1-hour video you watch online, not a big deal. There's a second financial management class that has to be done before the court will discharge your case. Again, this one takes about an hour to an hour and a half. And once it's completed, some deadlines go by, the trustee's done their job, then the case will be discharged and that notice will be sent out to you and to your creditors. Now, it's important to know that just because the discharge order gets entered by your judge, your case is not completely over. If your bankruptcy trustee has requested additional documents, additional information, you still have to comply with that request. If there are assets that are to be liquidated in your case, same thing. They can still work through that process until they get that done. And then once the trustee files the appropriate documentation with the court saying, hey, court, I'm done with my job, the court will then close your case. So there's kind of two steps at the end. There's the discharge, which is the legal order that eliminates liability on the debts. And then there's the administrative closing of your case at the end, which states that the trustee is done with their job, you've done everything you need to do, and the case is over. So, like I said, usually from beginning to end, filing to discharge about 4 months, sometimes a little bit longer. Depending on if there's other issues in your case, it may be administratively open a little bit longer. Thank you for watching today. Again, if you haven't subscribed, please go ahead and do it, and we will catch you next time.